Responsibility for Canada's criminal courts is divided between the federal and provincial governments. The federal parliament is responsible for formulating criminal law and establishing courts to administer various federal laws. The Supreme Court of Canada, the Federal Court of Canada, and the Tax Court of Canada are good examples. The provincial court system consists of provincial courts and superior court of the province. Provincial courts have trial divisions, superior courts have both trial and appeals divisions. The provincial court is the lowest level of Canadian courts. Judges are appointed by provincial governments and cases are tried by judge alone. They have the jurisdiction to hear summary conviction offenses, less serious crimes that carry a lighter penalty, and certain indictable offenses, more serious crimes that carry a heavier penalty. A person's first contact in the criminal court system is usually in a provincial court, because this court conducts all preliminary hearings, a judicial inquiry to determine whether there is sufficient evidence to put the accused person on trial. An appeal is an application to the higher court to review the decision made by a lower court. An appeal from the provincial court regarding a summary conviction offense is heard by a single judge of the superior court. If it's regarding an indictable offense, then it is heard by the appeals division of the superior court, a panel of 3 to 5 judges. The superior courts of the province are the highest criminal and civil courts in the provinces and have a trial and appeals division. They have jurisdiction in both criminal and civil matters beyond the lower courts. Judge and jury are used unless the accused and the provincial attorney general consent to trial by judge alone. By judge alone in the provincial court or by judge and jury in the superior court. Appeals from the superior court are heard in the superior court appeals division. 3 to 5 judges hear the case and the appeal is won or lost on the majority decision of the judges. The Federal Court of Canada is a court that hears cases involving the federal government, and it consists of both a trials and an appeals division. The appeals division hears appeals from federally appointed boards, commissions, and administrative tribunals. The Supreme Court of Canada is the highest appeals court in Canada, which also deals with constitutional questions referred to it by the federal government. The Supreme Court of Canada consists of a Chief Justice and 8 justices, all of whom are appointed by the federal government. 3 come from Quebec, 3 from Ontario, 2 from the Western provinces, and 1 from the Atlantic provinces. The court sits in Ottawa for 3 sessions a year, winter, spring, and fall. Cases are heard by a panel of 5, 7, or 9 judges, depending on the type of appeal.